Yes, sir.
Oh, I'm gonna put him, Mr. Wells,
Yes.
you're going into the.
We're going to come back.
First, I wanted to apologize to the court for being in a sweatshirt. But I just saw the email 10 seconds ago and I jumped on.
Nobody throws stones, okay? All right. What did you do with him?
I put him in the waiting room.
Okay.
I'm just gonna make an announcement since we have several people in Zoom. Possibly.
There's nobody here.
Just Mr. Wells?
No,
I just need to make an announcement so no one's over talking.
he's in the waiting room.
Okay.
We're live.
All right. The state of Georgia versus Mannoletto, Iverall Patrick, case number 05SC25898. The state is represented by Mr. Richard Kaplan. The defense is represented by Mr. Michael Tarleton. It's my understanding, Mr. Tarleton, is your motion and that you would like to call your first witness to the stand, Mr. Richard Hyde.
Yes, Your Honor. Before we begin, I do have some matters I'd like to put on the record.
Okay.
First, I'd like to renew my objection to proceeding as an evidentiary hearing without my client, Mr. Patrick, present. As I stated in the motion, because this is an evidentiary hearing, although there is precedent stating that a motion for trial does not normally require the presence of a defendant, because this is an evidentiary hearing, it requires the testimony of various witnesses. Mr. Patrick's input into questioning those witnesses would be valuable, particularly if we have to go forward on the ineffective assistance of appellate counsel issue, which would require him to give insight into not only what he did to communicate with counsel about going to proceed on his appeal, but also as to what questions need to be asked of counsel in terms of the actual examination of them.
And then as I've just responded off the record, I certainly would have granted your request, but the Department of Corrections through Ms. Woods told her that they're not transporting inmates. I don't know whether it's at all or whether or not it's for a motion for new trial, but they refuse to transport your client.
I understand, Your Honor.
Okay, I understand. We're just perfecting the record.
And in the alternative to that, I have an alternative proposal. In lieu of that objection, what I would propose today is that we proceed on the witnesses that we have present that relate to certain matters like the juror's conduct issue, for example, and the investigator in terms of what he has undertaken to find witnesses, but that we reserve ruling on the motion today and have a second hearing for two reasons. One, so that Mr. Patrick can be physically present, because we would reserve the witnesses where his.
I don't have a problem with that. Do you, Mr. Kaplan?
No.
But I don't want that delay to cause the federal court to think that we're delaying. I'm doing this at your request.
I understand, Your Honor. This isn't my request, and I fully understand.
The federal court and the attorney general on notice that how this case is proceeding now, because I was instructed to notify them. So that's fine with me. It's fine with the defense. So we'll give you another date down the road where your client can be physically present. And then you can reserve your arguments and reserve your rights.
Thank you, Your Honor.
All right, are we ready?
One more matter, Your Honor. At the second hearing, once we have a date for the second hearing, I'll be petitioning the court for a certificate of materiality. One of appellate counsel, Barbara Collins, now lives in Washington State. And obviously her testimony, she was appellate counsel for the bulk of this timeline. So her testimony is most.
How do you want that testimony to come?
Well, that testimony, I would prefer that a subpoena be issued for her, and we can do a per diem for her to be present, but I'll have to decide at a later time once we have the date, if that's impractical.
But if you want a subpoena, I'll give it to you. And how does it get paid for her to come here?
I believe that the mileage, I don't remember if the mileage is paid by the county or by our office. That's something I would have to check and verify.
But you want her in person?
I would prefer her in person because I would want
All
my
right.
client.
Well, I will sign whatever order is necessary to make sure that your client gets a fair hearing.
All right, thank you.
Anything else?
Just one more thing. We would also ask, both the state and I have agreed that we would prefer to argue by group.
That's fine. I'm not gonna do anything after today, right? We're gonna wait till the second hearing, right?
Correct, Your Honor.
And then in the end, I'll ask you to submit proposed findings of facts and conclusions of law in your favor. That way you're arguing by brief.
Sounds good, Your Honor. Thank you.
Okay, anything else?
No, Your Honor, we can proceed. I would call Richard Hyde.
Mr. Kaplan?
Can I heard on one issue?
Yes, sir.
I just, in the hopes that it would obviate objections for both Mr. Hyde and some of the juror witnesses, I just wanted to make sure that it was clear that the Supreme Court has stated that both directly or indirectly, that nothing from jurors about a narrative of their deliberations is appropriate. And I just wanted to make sure that, I want to put that on the record now, so that hopefully the questioning doesn't invade things that the Supreme Court has told us not to address here.
Mr. Tarleton?
Well, Your Honor, obviously the exception to that is if there was any misconduct during deliberation.
But I'll give you some latitude, but let's, if we're not gonna comply with that, then let's explain why.
Certainly,
the
Your
time.
Honor, absolutely.
Okay, so Mr. Hyde, will you please come forward? Sheriff, will you please administer the oath to Mr. Hyde? Please remain standing and raise your right hand.
Do you swear and or affirm the testimony you give the court the truth, the whole truth, nothing but the truth?
I do.
Take your seats. David, spell your first and last name for the record.
Richard Hyde, Hyde.
Good morning, Mr. Hyde.
Good morning.
What's your profession, Mr. Hyde?
I'm an investigator
How long have you been an investigator?
since 1979.
Prior to being, and this is as a private investigator since 1970?
No, I'm not a private investigator. I started as a City of Atlanta police officer,
And that was in 1979?
79 to 89.
And during that time, you were an investigator with the police department?
I did a little bit of everything.
And as part of your job as a police officer, were you tasked with locating and interviewing witnesses?
Yes,
And how long have you been in the practice of locating and interviewing witnesses?
42 years.
Now, in the process of your career locating and interviewing witnesses, have you had any special training in doing so?
Let me interrupt you a moment. It's very well known about this witness's expertise and about his experience and his reputation. And I'll be glad to take judicial notice that he's an expert. Is that what you're getting at?
Yes, Your Honor.
Any objection, Mr. Kaplan?
So, Your Honor.
All right, based on the foregoing, I'm taking judicial notice that Mr. Hyde is an expert in investigations and private investigations and locating witnesses. So with that, you can move on.
Thank you, Your Honor. Now, Mr. Hyde, how did you come to be involved in the Mannoletto case?
I was assigned by a court order to assist the defense.
And you recall when that was?
I do not. Last spring, maybe.
Does April 2020 sound about right?
That sounds good.
And you recall when we first spoke about the case?
Yes,
Was that just after the order was issued?
yes. It's in probably 1st of May, last April.
Who contacted you first?
I think you did.
And at that time, was I able to identify any issues that I wanted you to investigate?
No.
Did that change at a later date?
Yeah, I got an email from you at a later date. I don't have the date in front of me, but you said there were some things you wanted me to look at.
Does late summer, early fall of 2020 sound about right?
Correct.
And at that time, what did I ask you to look into?
Jurors, you wanted me to locate the jurors that had been on the case and speak to them.
And in doing so, did I ask you specifically to ask them any questions about anything? in
Yes.
particular? What was that?
About the pregnancy being mentioned by some of the jurors during deliberations or before deliberations started.
Did I provide you with a list of the jurors at that time?
You did.
What were the next steps that you took after being provided with that list?
I started trying to locate good addresses on the jurors. It had been such a long time. I didn't expect to have much success actually, but did my normal things to find people. And then I went out and knocked on doors.
And ultimately, were you able to locate addresses for all the jurors on the list?
Yes,
And when did you begin researching to locate these witnesses?
September 14th.
Or were you able to make contact with any of the jurors during this investigation?
Some, yes.
When did you start being able to locate and actually make contact with the jurors?
Within the last month.
What, if anything, prevented you from being able to do so sooner than the last month?
Well, the pandemic, and then my mom died from COVID, and my father's on a respirator, so I've been distracted.
I'm very sorry to hear that, Mr. Hunnich. Now, when you were able to talk to jurors over the last month, do you recall which jurors you were able to talk to?
Yes.
Which jurors were you able to speak to?
Well, I'm gonna look at my list where I have the names.
Certainly, if your recollection, if you were surprised by the list, let me go ahead and present that to the state. Approach Chairman.
Certainly.
This list is your witness log that you prepared for the
Right,
closing
but
investigation.
there are also a couple of non-jurors on there also.
And by non-jurors, you mean prior appellate counsel and trial counsel?
Yes.
Martha Collins and Philip Jackson.
Correct.
Is your recollection refreshed by the witness log that you're viewing right now?
Yeah, do you want me to name them?
Yes, please.
I spoke to Patrick Bentley on March 16th. Spoke to Tristan Farmer, talked to Mr. Farmer on the 22nd of March. Talked to Philip Jackson or Judge Jackson around March the 18th. Spoke with Lisa Norris on the 22nd. Talked to Ms. Petaway on the 22nd. Talked to the father of Gwinnett Latanya Scott. She is in California and not available. And then I spoke to Joel Simon on the 23rd.
Now, it turns out that a number of these witnesses have moved out of state. Is that right?
It appears to be. I have not confirmed that they're out of state. And by confirming, I mean I haven't talked to them and I haven't knocked on the door in California or North Carolina or Alabama.
But from your research, it does appear that their latest address is.
Yes, sir.
out of state.
It does.
Now, the witnesses you spoke to, did most of them did not remember the deliberations of this trial, correct?
Correct. They said they did.
So, starting with Mr. Bentley, he's one of the jurors who was not able to remember the deliberations of what occurred during deliberation.
That's correct.
Same with Mr. Tristan Farmer.
Correct.
Same with Mrs. Petway,
Correct.
as well as Mr. Simon.
That is correct.
The only witness who was able to remember what occurred during deliberations was, in fact, Lisa Norris. Is that right?
Lisa Robinson Norris, yes, sir.
Now, in your experience as an investigator, is it common that witnesses are unable to remember things that occurred over a decade ago versus in the immediate aftermath of the crime?
It's common also for investigators not to remember that far back.
And would you say in your experience that a period of time over 15 years in particular is a long time to remember something that, let's say, isn't an aspect of one's own personal life?
Yes, particularly when I was talking to the former jurors, several of them, the majority of them said they had been on juries before, and some said that they confused what happened from one case to the other.
And in your experience, if you interview a witness closer in time to a particular event, are they able to usually recall details of the event more clearly?
Sure.
And do you have any, in your experience, any particular time, a period of time where you want to interview a witness as quickly as possible in order to have, for them to have full recollection of an event that's occurred?
Want to talk to them as quick as I can, while everything's fresh in their mind.
And is there any particular period of time where you feel, as an investigator in your experience, that it becomes increasingly, let's say, worthless to try to talk to a witness?
Well, assuming I can locate somebody after 10 or 15 years, it becomes increasingly difficult because time intercedes. Other events happen to the witness's life. They confuse things like the jurors not remembering what happened from one case to the other.
Now, finally, when you went to locate Ms. Collins, I actually asked you to locate Ms. Collins fairly late over the course of this investigation.
Yes, you did,
When did I ask you to locate Ms. Collins?
just a few days ago.
Yeah.
I think it was on the 22nd, maybe.
And you recall why I asked you to try to locate Ms. Collins?
She had been appellate counsel for your client.
And was there any reason I had not tried to, or I did not locate her myself?
You're just not as good as me, I guess. I don't know. We had other stuff to do. I'm in manufacturing, you're in sales.
Sure. Now, in locating Ms. Collins, did you get any indication that she no longer resided in the state of Georgia?
I did. I went to her home several times. The last address we had for her, which was in Jonesboro, Georgia. She hadn't lived there in some time, according to the people there. And the most recent current address I have, but not confirmed, is in Renton, Washington, which is a little south of Seattle.
I have no further questions. Thank you.
Any questions, Mr. Kaplan?
No, Your Honor. Thank you.
How did, I remember appointing Mr. Hyde because this case had a sense of urgency, especially with the federal court being involved. How has he been remunerated? Do I need to sign a court order making sure that he's been paid?
I believe so, Your Honor, yes.
All right, now who am I going to order to pay him?
I believe the county would pay him since he's court appointed.
Have you been paid, Mr. Hyde?
I hadn't billed anything.
Well, I would like you to submit to Mr. Tarleton a full and complete bill, including today,
Okay.
and submit that to me. And if you'll draft the order, I'll order that the county pay him. Whatever your hourly rate is, it's well earned. So let's do that. Let's do that within the next 10 days. Can you do that?
Yes, sir.
All right. So may he be excused.
Yes, Your Honor.
I'm very sorry about your mom. I didn't know that.
Thank you, yes.
Is your dad doing okay?
Yeah, he's getting better, I think.
But I'm very sorry to hear that. Good to see you, and thank you for coming. Good to see you, Richard. All right, who's your next witness? The other gentleman we had on the screen?
Yes, Your Honor, Philip Jackson.
Philip Jackson?
Judge, you all are ready for Philip Jackson?
Yes, ma'am.
Okay, I'm admitting him now. Good morning, Mr. Jackson.
Good morning, Judge Jackson. How are you?
He's on mute, Judge.
Judge Jackson, will you please unmute?
And your video for us. If you could turn on your video.
Hold on. Okay.
Thank you.
You're welcome.
Thank you for your patience.
That's all right. I apologize for being on mute. I forgot.
Okay, Mr. Jackson, Judge Jackson, will you please raise your right hand? Do you swear or affirm the testimony you'll give before this court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Tarleton?
Good morning, Judge Jackson. What is your current?
Good morning, Mr. Talton. I can barely hear you. If you can speak up a little bit.
Certainly. What's your occupation?
I'm an associate juvenile court judge with Fulton County.
What was your occupation?
I can't hear you.
Before you were a juvenile court judge, he asked, what was your occupation?
Well, I was an administrative law judge. I was in private practice. I was solicitor general. But for the purposes of this case, I was in private practice, and I took a conflict case representing Mannoletto Patrick in a criminal trial before Judge Lane.
Thank you, Judge Jackson, for getting directly to the point. I was going in just that direction. Now,
That's fine.
Mr. Patrick, what was your theory of the case at the time?
My theory of the case?
Yes.
Well, that the state couldn't prove that he was guilty. They had the wrong person. You mean, why did I ask for the new trial?
I know what I'm specifically asking for is because your theory was that they had identified the wrong person, they couldn't prove his guilt. What particular parts of the state's evidence or absence of evidence led you to choose that particular defense?
Well, I think the only kind of evidence they had was the victim ID in Mannoletto. So I think they did some type of show up, but there might have been some issues with that. And I think a co-defendant may have testified against him because they offered him a deal. And basically, as the state started to get into their case, and they brought the victim out, I asked the victim a series of questions to see how good his memory was and whether or not he can ID Mr. Patrick. I think I asked him, Mannoletto, Mr. Patrick was not present when the victim took the stand. I asked him questions like, how tall was the person that he thought that robbed him? And I stood up and I compared my height to the person that he thought that was robbed him. I asked him about the complexion of the person that robbed him, since it was an African-American male and I was an African-American male. And he gave an answer to that. And basically the series of questions that I asked, it wasn't close. I think I'm taller than Mannoletto. And he said Mannoletto was taller than me. The person that robbed him was taller than him. He said the person was about my complexion. He might have said a little bit lighter, but about my complexion. And Mr. Patrick was a lot darker than me. So basically, it wasn't a good identification for the person, and Mr. Patrick didn't fit the ID.
In addition to pointing out the flaws in the state's case, when you presented the defense, did you also present an affirmative defense?
Yes. Mr. Patrick said that he was with his girlfriend. She had just had a baby and had been out a couple of days before the incident took place. And I think she picked him up in a car and drove him someplace. And that was our alibi witness.
Now, your alibi witness, he had just given birth recently, is that right?
Correct. It's like a couple of days within a week, I know for sure.
Now, it seems you remember the case pretty well. Do you recall overhearing any part of the jurors' deliberations concerning your defense?
Yes. after the trial was over and they brought in the verdict, we were allowed to go back. We were allowed to go back in the jury room.
All right, okay. You're telling me, I understand your objection.
Thank you.
You're telling me that you're going to make a claim of juror misconduct,
Correct, Your Honor.
and therefore you're entitled to go into this.
Correct, Your Honor.
All right, I'm gonna give you some latitude. Objection noted.
All right. The prosecutor and myself went back in the jury room, and I think all the jurors were there. Maybe one of them might have left. And he started asking them questions about what did they think about the trial and what happened. And there was, because they had been out a couple of days, I think, and they were saying that at first they weren't close. A couple of people held out, and then a Black American, Afro-American female jury said that she basically told them that when she had a baby, she couldn't get up and drive a car a couple of days after that. And that was just out of the blue. I mean, if I'd known about it, I would have asked Mr. Patrick's girlfriend, was she able to drive, or brought up some other type of evidence. But that evidence evidently went into the jury room, and I only became aware of it when we went back to the jury room and they started talking about their deliberation and why they did it. Because I think there were at least a couple of gentlemen that said that they weren't convinced until they heard that evidence.
Now, do you know if that went beyond that particular juror's personal experiences, or if they went into any general research or brought any outside information about any postpartum complications?
No, I just remember she was saying from her personal experience, and she was explaining it to the other jurors like the way she was explaining it to us, that when she had a baby, that she couldn't do that, and she didn't think anybody else could, and she didn't believe the alibi witness. And because she didn't believe the alibi witness, I think that was more like one of the main parts of why they decided what they decided.
All right, thank you, Mr. Jackson. No further questions.
I'm sorry, did somebody say something?
Yeah, Mr. Kaplan, on behalf of the state, Judge Jackson's going to question you, please.
All right.
Morning, Jackson, how are you?
Good morning. How you doing?
Just wanted to make sure I heard you correctly. Did any juror tell you that there was any extraneous information brought to their attention in the jury room?
No, the female jury was explaining to them about childbirth and what she wasn't able to do, and therefore she didn't believe something to the effect that she didn't see how anybody just had a baby could get up and drive a car and pick him up a couple of days after having a baby.
Thank you, Judge Jackson. That's all I have.
All right, so Judge Jackson, your point is that juror didn't believe the alibi witness who was driving a car very shortly after having a baby.
Correct.
All right, anything further, Mr. Tarleton?
No, Your Honor, I released Mr. Jackson, and in light of that testimony, I released Ms. Morris as well.
All right, Ms. Morris and Judge Jackson. Thank you, Judge Jackson. Always good to see you, sir.
Thank you. Am I excused?
Yes, sir. Thank you.
Thank you all. Be safe.
You too. Do we have the other gentleman that you wanted? Is that who it is?
That's Mr. Wells. He can be released as well. His testimony would relate to what we would go into in the second hearing. So we would prefer to call him at the second hearing when Mr.
So we're done for today.
We're going to be done with witnesses for today. Yes, Your Honor.
All right.
So Judge, I have Lisa Norris and Malcolm Wells.
They've been excused for now, but if they're under subpoena, they remain under subpoena for a later hearing in person when we can bring everybody into court. Okay. And for the record, I'm doing that at the defense request. And I realize it's going to delay a final ruling on this, but I'm accommodating the defense request. All right. So we will stand in adjournment until sooner than later. Mr. Kaplan?
Your Honor, I do have witnesses that I would like to call briefly
Today?
today.
Sure.
If I may have a moment, Judge.
I just need to step out and text them, Your Honor.
All right, I'll be right back. Are they in person?
Your Honor, based on a conversation that I just had with Mr. Dodson, we're not gonna need those witnesses.
All right. So what I want is, I want you to work with Miss Woods as soon as we can to get those witnesses in person. Okay? I don't know what we're talking about. I don't know whether we're talking about July. I don't know whether we're talking about June. I don't know when we're talking about. But at some point, this building's gonna open back up and we're gonna have in-person hearings when it's safe and appropriate and everybody's comfortable. What I would like, Mr. Charlton, is an order. I'd like you to work with Mr. Hyde to get his invoice and then submit me an order to order the appropriate party to pay his bills. Okay?
Yes, Your Honor.
All right. And I appointed him because of the extraordinary nature of this case, and we needed to move it along. All right, so we will be in adjournment. Mr. Hyde's going to get you those records within 10 days, and if you get me something 10 days after that.
I will, Your Honor. I'll have that ready and I'll have a petition for specific materiality.